Hi, this is Bruce Moyer and Rachel Rose of the Government Relations Committee of the Federal Bar Association. And we're here today to focus on the subject of federalism in this time of pandemic and the push and pull between the federal government and state governments to protect public health and reopen the economy. And to discuss that topic with us today, we're delighted to have a leading constitutional scholar and legal analyst, Professor Jonathan Turley of George Washington University Law School in Washington, D.C., to join us. Thank you, Professor Turley, for spending time with us today.
Thank you, Bruce. It's a pleasure to be with you.
Thank you, Professor Turley. And our first question relates to the op-ed article that you wrote in the Washington Post that differed with President Trump's declaration that as the president, he has the ultimate authority to do the resumption of normal economic activity throughout the nation. In your op-ed, you basically indicated, not so, Mr. President. You further said that the authority under the Constitution to order the startup of economic activity lies within the states and the state governors, not the president. Now, 4 days later, the president appears to have agreed with your assessment that the Constitution is designed to limit federal authority and that principal authority can reopen the economy lies with the states. Can you please describe why the founders created such a system in which the police powers over the public safety lie within the states and federal authority is more limited?
Certainly. The fact remains that federalism is a strength, not a weakness, in dealing with a pandemic like this one. First of all, absolutism finds little sanctuary within our constitutional system of limited and shared powers. But more importantly, while federalism wasn't designed for a pandemic, it could have been designed for that purpose. You know, what it allows you to do is to rely on 50 states that can tailor their responses to a pandemic. 50 states that have intimate knowledge of the conditions on the ground and have the resources and staff to enforce pandemic rules. So the president was correct for weeks in describing the role of the federal government as secondary. It was odd when he suddenly spoke of absolute power over the states. That simply doesn't exist. Indeed, the Constitution was written to bar that type of claim of total authority. If there's one overriding value in the U.S. Constitution, it is to resist the concentration of power in any one branch or any one individual. So what the president was describing was anathema for the framers. So the framers could not have been more clear in the 10th Amendment. They effectively created the default position as resting with the state. So when federal push comes to state shove, the states generally prevail. And the reason they did that was not just to avoid the concentration of power, but they also believed this was necessary to fight tyranny. In a profound way, the framers decided that individual rights are safest when they're held the closest, and that is with your local and state governments. You have the greatest control and you have the greatest level of observation in a federalism system of these basic rights.
When does federalism and the reliance on state sovereignty give way to the preemption by the powers of the federal government? Can that sometimes occur?
Yes, and that has been a daunting question for the Supreme Court throughout its existence. The federal government clearly has authority under interstate commerce, and the creation of the Constitution itself was to move away from the balkanized system that existed under the Articles of Confederation. The the federal government does trump state powers in a number of areas. It can do that expressly through preemption or through field preemption. The idea that federal law is so present in an area that there's no room for state enforcement. That issue was prominent in the Supreme Court's consideration of the immigration cases. However, the Supreme Court has also held the line on state police powers. A majority of the Supreme Court have a strong fealty towards federalism principles. The court has repeatedly struck down federal laws as intrusive for state powers. That includes areas like the disposal of nuclear waste, where the Supreme Court struck down a provision requiring states to take control of nuclear waste that has not been disposed of in their jurisdiction. Even that was viewed as too intrusive. There's also a number of cases dealing with the commandeering doctrine. That is, the Supreme Court has held on various occasions that the federal government cannot commandeer the states to force them to carry out federal policies. One of the more notable examples was with the Affordable Care Act, where the Supreme Court nullified one of the provisions because it was a commandeering problem. The commandeering cases are relatively few, and some of the justices have never been enamored with that principle. But the Supreme Court has held the line on state police powers. Where you see the greatest controversy is what constitutes interstate commerce and how far the federal government can go in the regulation of the states. What President Trump was referencing was not a close issue. The idea that the president can close or open the economy of a state would violate a host of constitutional principles, not the least of which would be found in the 10th Amendment.
So, Professor Turley, building on that, from your perspective, can it be said that the president's power to reopen the economy lies more in his informal authority, the power of his bully pulpit, and the power of suggestion, underscored by CDC guidance to suggest actions that states take in allowing commercial and other human activity to resume?
Yes. The president's plan for reopening the economy got the balance right. It is a persuasive rather than command authority that the federal government is using in this phased plan. It leaves the ultimate decision to the governors. The president still claimed extra constitutional authority in saying that he has decided to give the governors this authority. But the plan itself is measured and fully constitutional. So the president has a great deal of persuasive authority. By suggesting when the economy can open, he offers some political cover to governors in following the federal lead. Now, there is more that the federal government can do, just not quite as much as the president suggested earlier. The federal government can restrict federal funds and cooperation for those states that are opposing the national plan for recovery. But the federal government needs to be careful. Coercion can become commandeering. The Supreme Court has clearly indicated that a line can be crossed where the pressure is so great that the federal government is making the states a mere agent of its policies. So it is certainly true that the federal government can exercise pressure on the states, but even that authority is not unlimited. The key is that what the president was suggesting earlier is as unnecessary as it is unsupportable. The president doesn't have to exercise command authority to nudge the country back into a reopening. The federal government has a great deal of resources. The governors want to stay in close cooperation with the federal government. There is going to be a great deal of stimulus money that has yet to be approved by Congress. So there are ample apples for the federal government, so that there's really not much need for a stick. But the president grabbed the wrong one when he suggested that he has this total authority.
And Professor Turley, how would your answer vary, and maybe it won't, in relation to the Defense Production Act?
Well, the Defense Production Act has been discussed in wildly different ways. The DPA has been used in this case correctly. It's been used as a cudgel for some companies that were not sufficiently motivated, but it is primarily used as a threat. Companies know that if they don't meet the expectations of the federal government, they can be the subject of the DPA. While there's room for criticism of the president over some of his statements, there's also room to praise his administration for some aspects of the response. FEMA has done a phenomenal job. The level of production and delivery of material is very impressive. And that's the curious thing about the president's comments, is that they stepped on his administration's best lines. You know, that there is a reason why the administration should take some credit for a successful rollout, including the use of the DPA. But what the DPA does is it gives added control over these companies, primarily in prioritizing production. It can also negate certain contractual agreements. It is not a license to take over control of the state. Nothing in the Act suggests that it has that authority. Indeed, there's a conflict here on both sides. For weeks, the media was chastising President Trump for not ordering an effective national quarantine. I find no authority in federal law or the Constitution for the president to order a national quarantine. There are regulations where the CDC can quarantine individuals. There's also an ambiguous provision where the CDC can take action if it finds that local governments are not acting in a sufficiently protective manner. But none of these provisions suggest that the president can shut down a state or order a national quarantine. The odd aspect of this is that when the president claimed that authority, the press correctly objected and said that it was extra-constitutional. Of course, that's true, but before he made that statement, it seemed like many people were criticizing him for not using such authority.
It's a delicate balance for sure. So my final question is it possible, from your perspective, to use the DPA to provide adequate testing on a state level, or would that too be deferred to the states?
Well, what the DPA can do is to force the production of tests and their delivery to the states. The CDC does have a provision where it could conceivably conduct large-scale tests within a state. It has that federal authority. So the DPA certainly could be used to force the production of tests and their distribution. Existing CDC regulations would allow the CDC to conduct extensive testing of its own in any given state. So, there's no question that there's robust federal authority in terms of forcing the production of tests.
Professor Turley, our time has come to an end for this conversation today, but we hope we can pick up with you at a future time. Thank you very much for explaining these important constitutional and statutory issues to us today. They certainly represent important guideposts in our collective civic education. And we would recommend to everyone that they read Professor Turley's op-ed in the April 14th issue of the Washington Post, which we have linked on the FBA website. So, Professor Turley, thank you again for joining us today.
Thank you all. It's been my great pleasure.